Afternoon, here with Suzanne Kingston and Barbara Corbett, and we thought we'd talk a little bit about arbitration. But before we do that, I thought I'd ask both Barbara and Suzanne to tell you both a little bit more about themselves. So, Barbara, would you like to start?
Well, I'm a family lawyer. I now work in Jersey, have my own small firm in Jersey. I've been a family lawyer for over 20 years, and I'm a collaborative lawyer, mediator and arbitrator.
Thank you. And Suzanne?
Yes, I'm also a family lawyer. I'm a consultant at Mills and Reeve. I was a partner with us for a long time. I'm a mediator, collaborative lawyer and arbitrator, and I teach arbitration.
Great. Well, that leads us on to talking about your interests, both of you, in arbitration. So, Barbara, what was it that sparked your interest, and how long have you been an arbitrator for now?
Oh, goodness me, I can't recall how long I've been an arbitrator for, but quite a few years now. And the interest was sparked originally because Suzanne had initiated the whole family arbitration system and the whole scheme of training. And I was aware it was going on, but it was actually the late Sir Peter Singer who pushed me towards it. He emailed both me and Felicity Haskins in Guernsey and said, right, this is happening. We'd like to spread it further than just England and Wales. And so would you two come along on the course? So we went on a course together, and so I was taught by Suzanne on a course in London several years ago now. And then subsequently I also that was the financial arbitration, family arbitration, and then subsequently when the children arbitration came as a possibility, I also trained in children arbitration as well.
Yeah. And Suzanne, what about you?
Yeah, so I had an interest in the idea of arbitration since probably about 2008, 2009. And I just had a vision, a thought that we could take cases out of the court system that I could see was very busy and could have arbitration in a similar way to you have arbitration in civil disputes. And so I was involved in a little working group that talked about that. And then the ideas evolved and we got more and more people involved. And then IFLA, the Institute of Family Law Arbitration, was set up. I applied for a job as a teacher and I got that job. And so the first financial arbitration training course was rolled out in 2012. And then the children's course followed later. So obviously before that, I'd had to be trained myself and be accredited in both as a financial and a children arbitrator. But I've taught all of the arbitrators in England and Wales, and some of them around the world. So it's been a really interesting gig for me, as it were.
And I think we're very conscious that so many cases in terms of private law children cases aren't actually being heard, even remotely at the moment. And we also expect there to be an upsurge once this current period of lockdown finishes. What would you both identify as the advantages for parents of going down the arbitration route?
Well, I think it's important for the solicitors and parties to just look, first of all, to just check that it's in scope, to see that what they want to arbitrate can be arbitrated. And we'll come on and talk about that a bit later. But in terms of the benefits, for me, I think it's having an appointed arbitrator that the parties agree that person stays with the case throughout and therefore has a real knowledge of what's happening in relation to the case. The arbitrator can often be contacted by email, and if it's an email, then it will be a three-way email with both lawyers and the arbitrator being on that email. I think having your own timetable is a real advantage. So rather than being in a court-imposed timetable, you can agree with the arbitrator what the timetable should look like. And that's often established right at the outset. And at the moment, obviously there's arbitrators like myself who's able to, and Barbara, to do these arbitrations relatively quickly. So if you wanted your case dealt with swiftly, we would be in a position to offer that. I suppose another thing to say is that confidentiality is absolutely assured because the arbitral process is entirely confidential. So off the top of my head, I've just named a few there, and I'm sure Barbara's going to pick up on some more.
Well, certainly the confidentiality point is very important, particularly in a small place like Jersey, in that people can be seen going to court and people know what's happening. Whereas in arbitration, the premises were it may be remotely, or when you actually have face-to-face arbitrations, they can be in chambers or in a suitable environment, which isn't a public place, so people can't see that there is a dispute happening, which is really helpful. And actually, particularly in Jersey, where we have high net worth families who really confidentiality is very important to them, that's a particular strength for arbitration in my view. The other one is control of the process, not just in terms of where it's going to be, when it's going to be, and what documents are going to be produced whenever. It's also how informal the arbitration is going to be. Some arbitrations can be as formal as a court setting, but others might need to be a little less formal, depending on the circumstances, the case, the parties, and the fact that you could have an arbitration where you can have coffee at different times and have time to move about and relax if it's in a physical environment is helpful, much better than a courtroom.
Yeah, and also I suppose the other thing to say is that the arbitration doesn't have to deal with the whole case. You can have just a very small, discrete part of a case sent to arbitration if that were helpful. And the process is entirely bespoke. So the arbitrator and the parties really sort of negotiate that. I mean, obviously, if there's not an agreement, the arbitrator imposes their view. But there's a lot of sort of consensual discussion in an arbitral process, which is really helpful to the parties' relationship going forward.
And I suppose
yes, that's right.
Yes, and I suppose from everything that you've both mentioned, a whole lot of advantages that really come from probably agreeing about your identity of the arbitrator, because of course for a lot of people going to court, that it can be a bit of a lottery in terms of sort of the person that's going to be dealing with their case. So once you have a solicitor and a client who are interested in the process of arbitration, what would be the next steps, Suzanne?
Well, I think from my point of view, I always like to have a pre-commitment telephone call. Normally can be a meeting, but in these times, let's say telephone call or Zoom call. Everybody's on Zoom the whole time. And in that, I would want both solicitors to be involved. It's up to them and really whether or not the parties are involved, but certainly the solicitors would be involved. And we'd be having a discussion about the arbitral process. This would be a free session, probably about 20 minutes to half an hour, talking about the arbitral process, what the case is about, whether or not just me checking it's in scope, so it's in adherence to the rules, the IFLA rules, talking about a potential timetable, how the case might unfold, what we're looking for in the case, perhaps having a discussion about fees, how much it would cost for an arbitration to be heard in this particular case, whether or not the arbitration needs a hearing or whether it could be on paper, and just generally sort of scoping out the process fully so that after that pre-commitment call, everyone's aware of how the arbitration is going to work, and they will then be signing the arbitral documents in which they're going to be bound to the process, fully understanding how it's going to work and the binding nature of arbitration. And I think that's absolutely crucial. So I think both Barbara and I would be offering pre-commitment calls or Zoom calls to just scope everything out so everybody's assured that they understand how arbitration is going to work.
Yes, and I think it's important as well as to what stage the case has already reached. I mean, has there been a CAFCAS report? Does there need to be an independent social worker report? Because clearly arbitration matters relating to children are as varied as families are, and sometimes more information, more evidence is required than in other cases.
And I suppose the other thing in that early meeting is to just check that there are no safeguarding issues, because that's absolutely imperative. The reason the children's scheme was delayed in its launch was to ensure that we had a very robust process for safeguarding. And I was going to refer here to the IFLA website, because there all of the documentation is really carefully set out with lots of guidance for practitioners, and I think that's really important.
Yes, I'd endorse that. The IFLA website is a fantastic resource.
So once the parties have gone through that initial scoping out conversation with either Barbara or you, Suzanne, what then happens insofar as the parties and their solicitors are concerned? Do you then set a timetable?
Well, they need to engage you in the process, so they need to sign the originating application, which is an ARB1CS. They need to go through the safeguarding requirements. They need to show that they need to send the ARB1CS to IFLA, so that IFLA know that this arbitration is going ahead. And then we will have a call probably, and if directions are needed, we'll have a directions appointment, just like you would have at court, that would then lead to a final hearing. And as Barbara's indicated, if we need an independent social worker's help to identify the wishes and feelings of the children, we would at some stage also appoint an independent social worker.
Yeah. So Barbara, from your experience, are there any particular categories of case that are best suited for arbitration? Well,
there are many and varied cases. It's more a question of the cases which aren't suitable rather than the cases that are suitable. Particularly, as Suzanne has said, where there's a safeguarding issue, then arbitration isn't suitable. It's important to make sure that the evidence that is available is there is sufficient evidence to assist, and that's why it's helpful to have an independent social worker's view, because if you've got the two parents contrasting views and opinions, there are times when children will say one thing to one parent and something different to the other parent, and they don't necessarily have an overview of all the circumstances. But it is important that these matters, that the children are safe at all times. So if there's any question of one parent alleging that there is any improper behaviour on the part of the other, or that the circumstances that the children live in with one parent isn't safe, then those cases really aren't suitable for arbitration. It's very, very recently arbitration has become available for relocation cases, and that's actually very helpful, because relocation cases aren't usually suitable for mediation, because there's not really a halfway house. Either you go or you don't go. So a relocation case is really a case where somebody has to make a decision, and arbitration is very well suited to that, because it's a more flexible process. So there can be other discussions and ways of looking at options which wouldn't necessarily be available to the court, but there is actually someone making the final decision, unlike a mediation.
Yes. So if you have a case that is suitable, and you've had you've obviously identified your arbitrator, you've had the scoping out meeting, the arbitrator and the parties have worked out what evidence is required in the case. Is there then essentially a hearing in the same way that you would expect to have at court, with evidence and submissions from the advocates? How do you tend to structure it?
Yes, really much the same. I mean, obviously, again, as discussed, this is a bespoke process, so you'd be discussing this with the parties and their lawyers, but mainly the hearings are just the same as court hearings. And at the moment, obviously, we're getting rather used to doing all of this remotely, and that throws up its own sort of challenges. I understand that 3PB have got all of the requisite technology to obviate all of those issues, so that's really, really helpful. And just to say as well, I'm working on a protocol at the moment for remote arbitrations, because I think it's really important for practitioners to feel that they understand how the practicalities work of something that's being dealt with remotely. So I think that challenge we're really overcoming these days, and how quickly we've overcome it. Amazing.
Absolutely.
That's right.
Was there something else that you were going to say, Barbara? Sorry.
Yes, there is always the option. There's the option of face-to-face in a room, a proper traditional arbitration, or a remote arbitration, face-to-face, by Zoom or whatever, but also written arbitration, so that the arbitrator can look at what has been provided by the parties and give a decision and prepare an arbitral award based on that information, or determination in children matters.
Yeah, I think that's perhaps important to say that if you have had a hearing, or if you've sent papers through for a paper arbitration, then the good thing about arbitration as well is that the speed with which the arbitrator deals with finalising the determination. So rather than waiting for judgments, as you often do in the court, for several months, in arbitration we've sort of set the gold standard that you should have your determination within 28 days. And mainly the arbitration determinations are delivered much sooner than that. And I think, again, that gives a certain amount of comfort to the parties to know that when they've appointed an arbitrator, the process will be dealt with speedily for them.
Yes.
Is it always the case that it's a written determination? Is that sort of part of one of the requirements with arbitration? So it's not delivered orally on the day, for example?
No, it's always written.
Yes.
Yes.
And then in terms of people going through this process and understanding that you've got a determination, what's the enforceability of that? Is there then a requirement to translate your determination into an order, which is then registered with the court? What's the sort of final process for the parties?
Well, one of the main features of our children arbitration is for the arbitrator and the representatives to discuss whether or not an order is required as per Section 1.5 of the Children Act. So one of the considerations is, should there be an order? And the parties' representatives will make submissions on that. Normally there's a consensus about whether or not there should be. And I think generally it is anticipated that arbitral determinations will be made into court orders, but it's not an absolute requirement, because there may be some cases where it's not necessary.
And have you found, Barbara, from your point of view then, that the courts will then accept the determination and approve the order? What have you found in your experience?
Yes, the court, certainly in Jersey, is very willing to approve an order, because of course it would be the idea would be it will be submitted in the form of a consent order, so it is likely to be approved. And yes, I mean, we don't have the same concept of zealous agreements in children matters as you do in financial matters, but nevertheless, if there's been a consent order signed following an arbitration, then it's likely to be enforceable.
Our president issued guidance about how the interface between arbitration and the family courts in July 2018. And I really would recommend that practitioners read that guidance, because it has a lot of very, very helpful information in it and shows how to commute an arbitral determination into a court order.
The process, they've got an order which is recognised and enforceable, so obviously another advantage to them.
Yes, and the courts have been very, very supportive of arbitration. There have been a number of cases which have endorsed arbitration, and that's been incredibly helpful to the process. So particularly I think at this time, where there will be such a backlog of cases, the courts will be very happy and anxious for parties in suitable cases to go to arbitration.
Yes, I listened to the IFLA seminar on Monday, and very much the message was that arbitration is here and here to stay. You must both be very excited about what lies ahead.
Absolutely, really excited.
Yes, and it's a better way for clients and their children because there's more flexibility, and the arbitration can fill in the gaps and correct the deficiencies that the court system has at the moment. Well, always has had.
Yeah, thank you very much, Suzanne and Barbara. So